But for recapturing the facts, my lord, there are two sets of cases, my lord. In some cases, MR distributors, existing distributors, have challenged the vacancy notification notified in their operational area with the proposal to delink dealers from their existing distributorship. So their volume of business will be reduced. On that ground, distributors came this court, and in some cases, fair price shop dealers came before this honorable court, challenging the vacancy notification notified in their operational area with the proposal to delink ration cards from their dealership. There are two types of cases, my lord. All are appearing before your lordship.
Yes.
But the ground for challenge in both the cases is vacancy notification has been issued invoking the provisions of 2013 control order. Just for capturing, my lord, big facts.
Just one more. Memo of appeal টা বের করে Yes.
In both the cases, ground for challenge is vacancy has been notified under a redundant law or non-existence law because 2013 control order has been superseded by Central Control Order 2015. So after supersession, invoking the provision of a redundant law, no vacancy can be notified. I have shown to your lordship on last occasion that National Food Security Act came into force on 10th September 2013, changing the entire concept of public distribution system. Now it is targeted public distribution system, TPDS. National Food Security Act came into force on 10th of September 2013. That is subsequent to both the state control orders. State control orders notified on 8th of August 2013, so far the rural area is concerned, and there are two control orders.
One is 8th of August 2013.
Another is 12th of August. Urban. And National Food Security Act came into force on 10th September, subsequent to that. Then, for implementation of the National Food Security Act, central government frame a rule that is called Targeted Public Distribution System Control Order 2015. Which came into force on 20th of March 2015. 10th of March 2015. 20th of March.
No, after the Food Security Act.
Then Central Control Order
of 2024.
20th March 2015. Central Control Order for implementation of the National Food Security Act, which will appear from page 227.
The Central Control Order
2000, my lord.
2015.
This is called Targeted Public Distribution System Control Order 2015 for implementation of the National Food Security Act 2013.
That is at page 221.
227. Well, two provision I shall show to your lordship.
No,
227.
This came into effect from
the 20th of March 2015.
Yes, that is at page 221.
No,
227.
227. 227.
Yes.
Well, two provision, if you will also kindly see from page 227. Kindly see, my lord, 20th March 2015 date. Whereas the central government is of the opinion that it is necessary and expedient so to do for maintaining supplies and securing availability and distribution of essential commodity, namely food grains, under the targeted public distribution system. This is the new concept under the National Food Security Act. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodity Act 1955 and supersession of the Public Distribution System Control 2001. But this English suppression, it will be supersession. Second paragraph, third line. Except as respects things done or omitted to be done before such supersession and save as otherwise provided thereunder. So, not anything done prior to coming into force this control order, that will continue. In otherwise, 2001 central controller had been superseded.
Yes.
Now kindly turn to the next page. One proviso. Section 1, clause 1, 2, proviso. It shall come into force on the date of publication then, provided that provisions of this public distribution system controller 2001 shall continue to have effect as against the corresponding provisions of this order in if any state which has not implemented the Food Security Act or is implementing the said act only in part. But this is the issue which has been considered by other division bench also. State's submission was before the coordinate bench that state has not fully implemented National Food Security Act. And in that case, 2001 is still in force. And relying on 2001, since 2013 control order has been framed, they can notify vacancy under 2013 control order. Our case is that National Food Security Act has fully been implemented by the state. So 2001 control order has no existence. And the moment 2001 control order supersedes by 2015 control order, automatically 2013 control order goes, and invoking any provision of 2013 control order, no vacancy can be notified.
Now, this central control order is of
15.
2015
My lord.
with effect on 20th March 2015.
My lord.
So your case is that as National Security Force Act has not been implemented in
Has been implemented. Our case is that it has been fully implemented. It is the state's case that it has not been fully implemented.
Has been implemented.
So 2001 control order goes, supersedes.
And consequentially
2013 order goes, because when they have issued the 2013 control order in exercise of the power under section 3 Essential Commodities Act, read with 2001 control order. Your Lordship may come, just take a note of 2013 control order at page 209. Sorry, my lord, at page 1.
That 2001 notification 8th of March 2013 and 12th August.
My lord, just for a moment.
Those two has gone since the National Security has been implemented in the state. This is your argument.
Yes, because it says unless it is fully implemented, in that case 2001 will continue.
So this 2000 it was formulated in terms of section 3 of the section. Which section you said?
Section 3 of the Essential Commodities Act. Read with control order 2001. Just for a moment, if you like, kindly take note.
Essential Commodities Act.
Read with 2001 control order. Central control order.
Yes.
But for your lordship satisfaction, first kindly take up page 165 for a moment.
No, that you have taken us. That
So,
earlier you
Section 3, read with 2001 control order.
Now you said that state, the court, you were saying that a report was filed before the writ court. As regards
That I am coming.
Yes.
Some time may be given to me by, because some options have to be shown before your lordship.
You have shown that.
No.
Mr.
Subsequent thereto, some orders has been passed by this honorable court sitting in the division bench. That I shall place before your lordship.
That you have placed.
So, my lord, no, that I have not placed.
That coordinate bench order.
Justice Das presiding over a bench, coordinate bench, passed an order in Duwari Reshort case.
Please.
Yes. So, my lord, up to that, my case is that 2013 control order became redundant. You cannot invoke any provisions of that control order. Now, your lordship, branch of writ petition has been moved. Order has been passed. If you lordship kindly turn to page 318. In all these writ petitions, interim order has been passed. So far the dealers are concerned not to detract ration cards, and so far the distributors are concerned not to detract the
So,
dealers.
Mr. One thing, you were saying that even if the new order is implemented, then also it should be done in accordance with law.
My lord. if the declared vacancy under 2024 control order, which they have promulgated on 1st of August 2024,
So this 1st of August 2024 control order was issued on the basis of the 2015, which came into
my 2000 National Food Security Act and 2015 control order. Now they have complied by issuing a new rule.
that is
control order.
2024.
1st August.
So your argument was that if 2000 in compliance with 2024, if fresh vacancy is declared, you don't have any objection to
I have
that.
no objection.
Then please explain us that if the vacancy is declared on the basis of 24 and the vacancy as declared earlier, where does your grievance fit in?
My case is that I have made an infrastructure.
You are the
Existing distributor of the area.
You are the distributors and the fair price shop owners.
Of fair price shop owners.
You are representing both.
Yes. So far the distributors are concerned,
Hmm.
some dealers have been tagged with us. So this is a three-tier system. Some dealers have been tagged with the distributors.
Dealers have been tagged.
And so far the dealers are concerned, some ration cards have been tagged with them. But I have submitted before Lordship on last occasion. This
No,
is a-
distributors, please explain to
No,
us.
just I am explaining. Three-tier system. Distributors lift their allotted quota of ration articles from the godown of
Yes.
the FCI or the state government godown. They lift it and store it in their godown, distributors.
Hmm.
Then they distribute it to the dealers.
Tagged with them.
Yes. So
So-
if the dealers are detached with the distributors, they will suffer for business. Volume of business will be reduced. On that count, distributors are coming, challenging the fresh vacancy in their location. Because if that particular gentleman is appointed, any person is appointed, some dealers shall be dealing from the distributors. And so far the dealers are concerned, if any dealers is appointed in the operational area of the existing dealer, ration cards will be detached from the existing dealers and it will be tagged with the new dealer. So volume of business will be reduced. And ultimately held that this scheme is ultra vires. Now kindly turn the page 35. This is very important. Paragraph 25. Well, Mr. Cord leading me in that case. That main thrust of argument of Mr. Cord, learned senior counsel, is that after coming into force the Central Government Control Order 2015, Rural Control Order 2013 and Urban Control Order 2013 have become non-existent, as the Central Control Order 2001 has been repealed by the Central Control Order 2015, hitting at the very root of the existence of Rural Control Order 2013 and Urban Control Order. Same issue. From reading of Central Control Order 2015, it is, however, found that that has been made in exercise of the power conferred by Section 3 of the Essential Commodities Act in supersession of the Central Control Order 2001. In Clause 2 of Central Control Order 2015, it is specifically provided that provisions of the Central Control Order 2001 shall continue to have effect as against the corresponding provisions of this order in any state which has not implemented the Food Security Act or is implementing the said act only in part, which I have shown to your lordship from proviso. Learned Advocate General submits.
Why it is said from reading of the Central Control Order 2015, it is however found that it has been made in exercise of power under Section 3 and in supersession.
Yes.
Why in supersession?
2001. I have shown to your lordship 2001 has been superseded by 2015.
Yes.
But with saving clause, proviso that
it has
if any state. Then next paragraph. Learned Advocate General submits that taking into consideration the mechanism which has been provided in National Food Security Act and the Central Control Order 2015, like monitoring, etc., the NFSA Act has not yet been implemented in full in the state. It is submitted by Mr. Call, Learned Senior Counsel, appearing for the appellants, that NFSA Act has been implemented in full force in the state and thereafter only the duration scheme was made. When Learned Advocate General, being the highest officer of the state and supposed to be in known The facts in submitting the National Food Security Act has not yet been implemented in full and in the state.
Mr.
It-
Shara, it is 18th status as on 28th September 2020.
Yes, what happened? Before the Supreme Court,
This was taken to Supreme Court.
yes, state filed a SLP
Acha.
saying therein the submission which has been recorded is not correct. Advocate General has never said that it has not been fully implemented.
Very good. But now today
So-
we are in 2025.
Same thing, whether it has been implemented or not.
That is why they have used a report
No,
saying that
at that
certain-
material point, this SLP has been filed in 2022 by saying before the Honorable Supreme Court.
that this was a erroneous sub.
Yes, meaning thereby it has fully been implemented.
As
Meaning thereby it has fully been implemented in 2022. On last occasion, I have placed before your Lordship page 54, ground number R from this voluminous SLP. May I hand over, my lord, the typed copy of that portion only?
we are accepting you.
No,
that
just
you will reply.
what is the content? This is the ground number R.
So your contention is in 2020-22 it was implemented.
Fully.
So accordingly 2001 control order
They cannot
becomes
take advantage
redundant.
of the proviso, which says unless it is fully
Very
implemented.
good, but now they have used an affidavit. They are saying that only mere cosmetic changes have
That is
been
also in my favor, but that is not the act also. Why I am saying this is reforms part. Reforms is always continuing. Section 12, which as they have relied, I shall show to your Lordship, which they have relied on.
So.
Kindly read, my lord, this paragraph.
Paragraph.
My lord, this only page, the ground art of the SL. Entire copy is with me, but I am not handing over that voluminous copy. So this is the submission before the SL, before the Supreme Court, that the submission which has been recorded by the division bench in duration scheme, that state has not fully implemented the National Food Security Act is not correct. Vice versa, state has fully implemented the National Food Security Act. That is my submission. The only case made out, and I lost the writ petition on the ground that it has not been fully implemented. 3 issues has been framed, 2 issues in my favor. In the so far the other issue is concerned, issue number 2, the learned single judge held, since it has not been fully implemented, 2001 is still in force. Despite placing this SLP before the learned single judge. And that has been dealt with by the learned single judge. I shall show to your Lordship. But SLP has been affirmed by the
Dilona, pencil Dilona. Yes.
but SLP has been affirmed by the Special Secretary.
Now, very good, very good. Now let us come to the next
My
one.
lord, my lord. Next. Now, your Lordship, kindly
So Duare ration scheme was in
declare
derogation.
ultra virus
No, that was in derogation to the targeted scheme or any.
2013. Invoking provisions of 2013, the duration scheme has been framed. Numbers of grounds, it has been challenged. One of the ground was, you cannot invoke 2013 for framing duration scheme.
Yes.
The division bench declared ultra-virus to the duration scheme. But in respect of the ground, that whether 2013 control order was in force or not, says, since the Advocate General submitted,
Not implemented.
subsequent thereto, Supreme Court,
So
it is
your ground stands according. It remains to be a redundant. Yes.
now on the same ground.
Show us that portion of
Just
that portion of the order of the
Fine.
planets. That is page 338.
page my lord, just
338, 3 questions frame.
which
What are you-
my lord, that I'm showing you. It starts from page 329, 338.
Now 343 is paragraph 2017 was your
But your lordship kindly turn to page 338.
338 আবার কেন যাও?
Three issues.
That you have showed us.
Then my lord kindly come to page 341.
341, yes.
Count, dhara. Count number, my lord. First count has been in my favor. Page 341.
First ground is para 13.
My lord.
Second ground is para 17.
My lord.
And the third is para 21.
My
So
lord.
which was against you?
My lord, kindly come to page 341.
Yes.
Last part from bottom, query number 2.
Query number 2.
This is the trust
This
of
is
the
against you.
against me. May I read, my lord?
Query number 2 is clause Roman 2 of paragraph 8.
Paragraph 13, query number 2. Yes.
Now para 14.
My lord.
All of it are good. The repetition is allowed.
Pardon?
All points have been argued on the other page.
Yes, Mr. Bandyopadhyay, we make our endeavor to cut short the learned council. We will immediately revert. Order impugned. Paragraph 14 you have shown.
Yes, my lord. Paragraph 14.
Stay here. I am not available for every day.
Yes.
Paragraph 14, my lord. I mean,
He is available for every day here. I am not available for every day here.
But we have to hear the state, Mr. Bandyopadhyay. You will argue.
Hear this state, but the petitioner if he argues for days and days after.
Give us 15 minutes, Mr.
Thereafter, finally kindly extend the interim order.
Yes.
paragraph 14.
That you have placed, Mr.
Yes. So, your lordship, just ask me where it has been dealt with.
Paragraph 14. We have
Paragraph 14 says, since the learned advocate for the state filed a notes of argument saying therein that it has not been fully implemented,
That is paragraph 17. That is what we were saying.
my lord.
Now, yes, anything
Yes.
else you want to show?
Next case, similar issue has been considered by a single judge. When the learned state advocate submitted before the single judge, it has not been fully implemented.
Why you are taking
Yes, that same division bench says it is not proper. In duration scheme, you have said,
Where is that?
my lord.
That is the other
Your lordship,
coordinate bench.
your lordship
No,
keeps
Mr.
me according to my way. Otherwise, my lord,
We have allowed you the entire day, Mr. Sharda.
as
You said that you will take 15 minutes.
because
to
they
sort
have
out.
filed and my lord supplementary report on the last day. I have to deal.
Mr. Sharda, you conclude so that we can finish off the matter.
Yes, absolutely. But kindly take this.
And you will get your chance in replies. Let them say what they have to say.
But if I don't place my case,
Give it to him. Give the supplementary.
yes.
Yes, what you are showing.
And kindly see the division bench
Any
judgment.
point left out, any point left out after hearing them, you point it out in your reply.
Possibly that would not be proper. If I not
Yes.
place this, they cannot give reply to this.
Yes, tell us what you have
But
placed.
kindly come to page my lord 6. This is the division bench, same division bench, presided over Justice Dash. Single bench. This is a single bench order. I'm handing over the division.
Why you are showing it to us?
Because this case has been dismissed on the ground, on the basis of the submission of the state, that it has not been fully implemented. Then appeal has been papered before the same division bench.
Give me some reference, something.
Yes.
A single bench তো সব বলা আছে। Single bench judgment.
কপি দেবেন একটা।
So these against this appeal, what has happened?
Kindly come to my lord. Second paragraph.
তো।
Second paragraph.
Yes.
Kindly read my lord, paragraph page 2.
But why
Third
should
paragraph.
we go into this? This is in your the read court considered it.
Yes.
Impugned judgment.
Entire submissions, entire this judgment, all that has been recorded
Achha, show us what you are showing
from bottom, second paragraph.
in the appeal order.
Yes. While